Mover to reply, Majority Leader.
Thank you. Thank you, Mr. Speaker. I want to thank colleagues who have taken time to speak to this particular matter. Mr. Speaker, indeed, it's an interesting matter because it's not one that I'd have very strong feelings about on how a member decides on this particular issue. Because at the end of the day, I believe an apology that has been rendered and the punishment that this House rendered on the offenses that were committed by Senator Gloria Orwoba are personal. Therefore, if a member feels that indeed that particular member has owned up to their mistakes and has requested the House that they be given a lighter punishment, not that they are not punished completely, but be granted a lighter punishment. It is on that basis, Mr. Speaker, that I moved the House to reduce the sentence and the Senate to vary its resolution. There are a few things that have come up which I'll attempt to respond, Mr. Speaker. First is what Senator Sifuna raised with reference to the motion coming back to the House within a period less than 6 months. Mr. Speaker, sir, this motion was moved actually on the, to be specific, on the 23rd of September, 20th of September 2023. Therefore, it's far more beyond the 6 months period upon which you can bring a motion separate to the one that had earlier been resolved. Secondly, Senator Sifuna also inquired on the provisions cited, Section 17, 3D and G. The reference to them was to the punishment, not that the House has powers to do. Actually, the punishment that was meted to Senator Gloria by this House is in reference to those specific, that she be asked to leave the House for a certain period and also being asked to apologize. That is why, Mr. Speaker, in the final part of the motion, I have stated that there is a term there that when Senator Gloria Orwoba returns, should members agree with this motion, she will be admitted to this House on terms resolved by the Senate on 20th September 2023. So you have to ask yourself, what were the terms? If you have observed previously when a member has been kicked out of this House, it's also a very difficult experience. It's not something as easy as just walking back to the House. When she comes back, it is almost similar to the first day we came to this House, where you have the rostrum placed at the door there, and they formally apologize to all the people that they have wronged before the House finally agrees that they be admitted back. So, Mr. Speaker, it's not like we are making this sentence lighter. I have listened to Senator Catherine Noma, and I think there are two things perhaps you may need to remember. There were two cases on this matter. The one is where she contested the decision of the Senate, to which a full determination has been made, and the courts agreed with the decision of the Senate that actually we acted rightfully within the law to suspend her. And that's why the sentence now holds. The second matter is now the issue that you're referring to, where members are saying there's an individual who was maligned, there's an individual whose name was tarnished. That matter is still active before the court. And there is no way in which this decision, one way or the other, is saying that that matter before the court be ruled this way or the other. What we are resolving as a House, Senator Moma, is on the issue of the number of the days that she served the suspension. Is it 79 days or 30? And I felt, together with after consulting with colleagues, and said, the punishment she will serve anyway, because it needs to serve as a lesson. I continue to see sometimes us disrespect our own authority as a House, because every time I do something that is disrespectful in this House, Mr. Speaker, I am disrespecting the collective standing of this House, Mr. Speaker, before colleague senators and even before the country. Therefore, I want to agree with the decision that was made by the powers and privilege that for her conduct, Senator Gloria Orwoba must be punished. The only thing that we have requested you is that after having punished her, and given, in fact, the only thing that I reference to is the fact that she has since formally, or when granted an opportunity by the Speaker, apologized to the House, meaning that she has admitted that there is a way in which she behaved that was not up to the standing of a senator before all of us. Then I said, if that be the case, then I'd rather request the House that we review, not to waive the punishment, but just to review it from 79 days to 30 calendar days, which I find, Mr. Speaker, to be a fair ask of us colleagues, because like they say, to err is human, Mr. Speaker, that we can all sometimes mess. This does not in any way, Senator Eddy, take away the rights of the individual that you're speaking about. the clerk of the Senate. I'm sure that particular matter, and I wouldn't wish to speak long on that particular issue of the dispute between them, so as not to appear as if you are in support of this or the other particular person. I believe, because he strongly feels that his rights were violated, Mr. Speaker, that is a matter that is before the court. What is before us is a review of the punishment that this House passed on her. Remember, there is a case between the person who's accusing her, that she maligned her, and a case between her and senators, because senators felt that she had behaved inappropriately, and therefore senators punished her. This request is on the matter of the senators and the Senate of the Republic of Kenya versus our colleague, where we are saying, since our colleague has publicly come before us and said, I apologize, then let's review that particular sentence. I thought that will be clear and in any way does not prejudice the other matter that is between, that is in the courts, Mr. Speaker. So, Mr. Speaker, with those main remarks, I beg to reply. In accordance to Standing Order number 66, Mr. Speaker, I beg that we defer the putting of a question, given that I can see the number of people that are in the House, Mr. Speaker, wouldn't be sufficient to take a vote. And this is one such matter also where I would wish that when you are taking the vote, you have as many senators as possible in the House. I thank you, Mr. Speaker.
Very well, Senators, Honorable Senators, we are going to defer putting of the question till tomorrow or when we have quorum, and we will go to the next order. Order number 13, Clerk.
Order number 13, motion, report of the Mediation Committee on the Conflict of Interest Bill, National Assembly Bills number 12 of 2023.
Vice Chair of the committee, Senator Sigei. Give Senator Sigei the mic.
Thank you. I already have it, Mr. Speaker. Thank you very much, Mr. Speaker. I beg to move that the Senate adopt the report of the Mediation Committee on the Conflict of Interest Bill, National Assembly Bills number 12 of 2023. Yes, National Assembly Bills number 12 of 2023. Mr. Speaker, this particular motion was laid, report was laid on the table of the House on 5th of December 2024. And Mr. Speaker, as I move this particular motion, it is incumbent upon me to run members through the very salient issues which we dealt with in the course of the joint sitting of the National Assembly JLAC and this particular House. And Mr. Speaker.
Senator Sigei, sorry, could you please move the motion properly as indicated on the order paper, and then you can explain.
Thank you, Mr. Speaker. I will go through it again. I beg to move that the Senate adopts the report of the Mediation Committee on the Conflict of Interest Bill, National Assembly Bills number 12 of 2023, laid on the table of the Senate on Thursday, 5th of December 2024, and further that, pursuant to Article 113, Sub-Article 2 of the Constitution and Standing Order 167.3 of the Senate, approves the mediated version of the bill. Thank you, Madam Speaker. I felt the need to allow the chair to settle down so that I proceed. Madam Speaker, this particular bill was passed by the National Assembly on the 30th of November in the year 2023. It was amended and passed by this House, that is the Senate, on the 4th of June 2024, and the Senate's amendments were thereafter forwarded to the National Assembly for consideration. It is thereupon, Madam Speaker, that on the 24th of July 2024, the National Assembly rejected the proposals for amendments which were made by this House in the course of its consideration of the bill. And pursuant to this particular rejection, Madam Speaker, a mediation committee was established. And this committee, for purposes of record for this House, comprised the following members: Senator Okongo Omogeni, Senator Mohamed Faki, Senator Manzo, Senator Crystal Asige, Senator Gloria Orwoba, Senator Mungatana, Senator Joe Nyutu, and Senator Chute. This committee was co-chaired by yours truly, myself, together with the chairperson of Justice and Legal Affairs Committee of the National Assembly, the Honorable Murugara. Madam Speaker, we had 7 sittings, where in those 7 sittings we went through the various contentious issues and clauses on this particular bill. And I will just, for the highlight, just pick a few of them. One of which, Madam Speaker, is the fact that this particular bill is such an administration of the conflict of interest aspect, which in line with Article 79 of the Constitution was to reinstate the administration to the Ethics and Anti-Corruption Commission as the primary enforcement authority or body. Madam Speaker, the earlier proposal and the amendments that were made by this House had expanded the primary authority not to domicile from EACC, that is the Ethics and Anti-Corruption Commission, but other bodies which, following consideration by the Joint Committee, the committee came to conclude that it is incumbent upon the Ethics and Anti-Corruption Commission to be the primary authority or the primary organ to administer the act. And that was mutually agreed upon by the 2 houses, that is membership from the National Assembly and the membership from this particular House. Secondly, Madam Speaker, another very important provision which was agreed upon was with regards to at what point do we make reference to a public officer being of a possibility to have personal gain where conflict of interest can be apparent in a situation. And in this particular case, members indeed agreed that as long as you were holding a public office, there is a very high likelihood that you will have personal gain on an aspect that a conflict of interest can be seen to be apparent, and therefore in instances where, for example, an issue is before the House being debated in 1 or 2 of the proceedings of the House, as a member you must, or you are required by law, and in this case this particular law, you are required to disclose that fact so that you make a choice, or the presidium at that time makes a choice as to whether you should be allowed to participate in such proceedings or not. And it is not only going to affect the committee of the whole, even in committee sittings of the various standing committees of both the National Assembly and the Senate, where a member has disclosed that conflict of interest could exist, then it's upon the chairperson who is presiding over and that particular member to make a choice whether such a member will continue sitting in the committee or not. And that particular provision, Madam Speaker, was uniformly agreed because of the desire to guard and protect the public officers and state officers from being exposed to participate in proceedings where they will be seen to have either influenced or in one way or the other involved themselves to make sure that a position that would be either prejudicial to the public or in benefit to them is involved if they are allowed to participate. That is one crucial provision that members agreed. Thirdly, Madam Speaker, is also a provision which was a bit contentious on prohibition by law of dual employment of public officers. In this particular aspect, it had been declined by the Senate, but the National Assembly had pushed that we need not have a public officer have dual employment. But the position the committee took was this is a provision that is already existing in other laws. And therefore, just for the sake of this conflict of interest bill, including it is basically what members called redundancy in enactment of laws, and members agreed unanimously to reject the inclusion of that provision because of the fact that it is already a provision that exists in Public Officers Ethics Act, which is an existing law, and it was superfluous to include that particular provision in the conflict of interest law, and the committee jointly agreed that that provision be deleted. Madam Speaker, as regards the aspect on declaration of income, assets or liabilities by members, the Ethics and Anti-Corruption Commission on this particular proposed bill was required to also be involved in ensuring that such forms are filled in a more extensive way than the one that exists currently in the law. And the committee, Madam Speaker, was cognizant of the fact that the Public Officers Ethics Act indeed has got a provision requiring any public officer to make annual declaration of their assets, liabilities, and also income. And there is an existing schedule that requires how members are supposed to fill in and disclose those particular requirements on an annual basis. And therefore, where there is such an existing provision, it would not be necessary to still reintroduce it in this law. And similarly, it was agreed by the membership that it will be unnecessary to amend the schedule which serves that particular purpose in the existing law, and therefore members unanimously agreed that particular provision was to be excluded in the final draft. Another very interesting provision, Madam Speaker, that was considered in the course of this particular engagement by the Joint Committee was the requirement of a public officer who is a subject of investigation to be asked to step out of office for the entirety of the period of investigations. We are all aware that in this country, wherever there is any investigation that goes on, it is not known for how long will it take for such a process to be concluded. This particular law seeks to introduce a limitation on the time of suspension from an infinite period to a period of 90 days. And we are saying within these 90 days, whether or not investigations will be concluded, the moment 90 days lapses, the person is going to be automatically allowed to resume office, or if the investigating agent seeks to extend that period, they should do so pursuant to a judicial process, so that we protect the interest of the person who is a subject of investigation, as well as the public, where such investigation was to seek to protect, whether it's public resources or in event of abuse of office. We are able to protect both the victim and also the office itself, because if we allow investigations to continue forever, people might abuse in most cases where they want to ensure that I don't get back to office. They delay the investigations, for instance, for a period until when my contract in office ends, or for whatever period of time they deem appropriate in the interest of those who are doing the investigations. We therefore then as a committee, Madam Speaker, agreed that if you are a subject of investigation, the timeline within which the investigation should be done is 90 days, failure to which then the agencies must seek an extension through the normal process, whether it's judicial or otherwise. They must formally do so, so that we know we also enable and facilitate such investigative agencies to be efficient in what they are doing, because by being efficient, they are able to conclude investigations. If it's a matter of protecting public resources, that can be done within a reasonable time. So, Madam Speaker, I want to conclude by saying that the entirety of the bill and the concerns which were contentious, raised by the Senate and National Assembly, were dealt with by this joint committee in the 7 sittings that were convened, and a final draft which has been tabled before this House. And I ask the members of this House to support this particular motion so that the bill can finally be approved and enacted by the National Assembly, having put into consideration the concerns as were raised by those who participated in the stakeholder engagement, the public participation, the National Assembly having also done their bit in public participation prior to them coming up with the bill, and this particular House having considered also contributions from a number of stakeholders, including the Ethics and Anti-Corruption Commission, which is going to be the primary entity that will administer this particular act, among other players who also brought in their concerns, which were considered by the Justice and Legal Affairs Committee, and ultimately the draft that now went brought back and is the subject of this particular motion. Madam Speaker, the motion, therefore, that is before this House today is one that has put into consideration matters beyond the committee, matters beyond the House, and I urge the honorable members to support. And Madam Speaker, I would like to request the Honorable Senator Eddie Okech to second this motion. I thank you.
Senator Okech.